Welcome to the Roanoke Real Estate Podcast with your host and realtor, the Frazier Hughes Experience. And do not forget to Hughes it or lose it.
Okay, on the podcast today with us, we have Julianne Naff. She is an attorney, and she's here locally in Roanoke with Anderson, Desimone, and Green. And she practices estate planning and much, much more. Her background shows her as, and you can correct me if I'm wrong, Julian, you're a graduate from Virginia Tech.
That's right.
And then you went to Charleston School of Law.
I did my first 2 years of law school in Charleston, which I loved it down there. But I grew up in Virginia, so I wanted to come back, and I did my last year at Washington and Lee.
Okay, and you're a frequent guest speaker on topics such as estate planning, elder law, long-term care planning, guardianship, and special needs. And you're a member of the Virginia State Bar, the Trust and Estates and Elder Law sections of Virginia Bar Association, and the National Academy of Elder Laws. Good grief! I mean, you are you're doing a lot. Locally, you are the treasurer of the Virginia Women's Attorneys Association, Roanoke chapter, and is a member of the Roanoke Bar Association.
That's right. Yep.
All right, and so hey, I appreciate you coming on the podcast today. I felt like it was really important to have you on, having to do with real estate and real estate here in Roanoke and southwestern Virginia, due to the fact that people don't always have a plan, before they pass away, or if their home is suddenly sitting there and they're no longer there with it. And I thought, hey, let's get her on the show, and we can ask her some questions and. Because I think some people are very familiar with this. Some people have a plan, and some people do not have a plan. So, the first question is what is estate planning? What does it entail?
So, estate planning is I would consider it preparing for the transfer of your assets. So, everybody has insurance, or a lot of people have insurance, real estate, different assets that make up the things that they own. And so estate planning is just working with somebody, or you can do it on your own, but sometimes it helps to work with somebody to get those affairs in order so that you know where it's going, who's getting it, who's in charge. So I think it leaves people with peace of mind when they know, okay, I have my plan in place, I have it in writing, I know my wishes will be carried out. So that's what I would consider estate planning.
Okay. And what else do you do along with anything else besides estate planning?
You mean in my practice, or what should you do? Yeah,
I mean, I'd seen here that you also you do other things besides that.
Like elder law, long-term care planning. Yeah, so along with estate planning, and estate planning has many pieces. So you can have a simple estate, you can have a very complex estate. Some clients come to us and say, well, not only do we want to plan for the transfer of our assets upon our passing, but we also want to protect assets. We have a family farm that's really special, and it's been in our family for this many generations, and we want to make sure it stays in the family. We don't want to have to liquidate this farm to pay for our care if we ever had to go into a nursing home, let's say. Because as you know, the cost of care is really expensive in a nursing home. It can drain people pretty quickly. So that's another piece that we often look at when we are starting the estate planning process. We say, are there assets that you want to protect while you're alive as well, to pass down to your children?
Yeah, so if you go into a nursing home, you mean that they can't come and take your property?
Right, and you do need a window of time to protect those assets. So if you say, I have this farm and it's really special, we would have to make plans to transfer it 5 years prior to applying for public benefits. So Medicaid is the state program that pays for long-term care when you run out of assets or money to pay for your care, or if you don't have enough income to cover that monthly cost. And in order for them to pay, you have to have not given out any gifts within the last 5 years. If you do, they can penalize you for that transfer. So we need a window of time to do planning. So planning ahead is key. both with estate planning, of course, but also with asset protection.
Yeah, I've dealt with many properties, and I remember one recently where the son. So the son is living with the mom, taking care of her, and the dad is in the nursing home. And I was like, okay, well, I'm going to be your realtor, and I'm gonna help you all sell the house. And they said, well, first we got to call Medicare. Or is it
Medicaid?
Medicaid, rather.
Yeah.
But and then you come to find out that they can't sell the house; that Medicaid's going to get the house.
Well, there is an exception to some of these rules. So if it's a married couple and the spouse is the community spouse, is what we call the spouse that's at home. So you have your spouse that's in the nursing home or facility, and you have the spouse that is in the home. They're the community spouse. As long as they're living in the home, it is exempt. They won't force you to sell it. So I'm not sure, who they spoke with at DSS, but usually, and in all cases that I've been working with, the house is protected as long as the spouse is living there. There are equity limits, though. Around, in the $500,000 range, you can own your property up to that amount, and it's exempt.
What if
and there are some... I'm sorry?
What if the spouse wants to sell it that's living there? Is she allowed to?
She can, but the proceeds you may have to spend down. It kind of depends on where they're at in the application process. So that would be a case-specific analysis we'd have to do to see, are they going to purchase a new home with the proceeds? So it kind of depend on what they wanted to do with those proceeds.
Okay, gotcha. All right, very good. So who should get it? Who should practice estate planning? Everybody? I mean, what's the difference between estate planning and a will?
Yeah. So that's a good question. So I think anyone who's over the age of 18, whether you have a small estate or a large estate, you should look into estate planning and making sure that your wishes are going to be carried out no matter how big your estate is. So we work with people of all different asset and income ranges. You may hear my assistant in the background. I'm working from home. So we work with people, with all different sizes of estates. So if you're over 18, you have capacity to understand what you're setting up, then I would recommend looking into, setting up a will or a trust. And there's, differences between the two. There's pros and cons between the two, but your standard will is a document that does not avoid the probate process. So you still have court oversight. If you set up a will and you pass away, your family will oftentimes have to work with the court, your local court, to administer your assets. Some people don't like that, so they want it private, and the trust is a route, a living trust is a route you can take to avoid that probate process. It's a little more costly to set up front, but it saves money on the backside. It's private, no court fees, so a lot of people like that option. And you can put contingencies, on an inheritance, which is nice. You can say, I want to make sure that this individual gets their inheritance over a period of this many years because they're not great with money management. So you can put those contingencies on the inheritance, which is nice, through that living trust.
Yeah, what I'm trying to say is that, you always hear the story of, that guy is 20, but when he turns 30, he's going to get $1 million. What kind of will or plan is that? What is that called?
It sounds like someone has set up a trust for him. So, meaning maybe at 20, whoever is leaving him this inheritance felt like he wouldn't be mature enough or financially savvy enough to manage that kind of money. So they said, well, we'll wait and give him his inheritance at a later date, maybe when he's more mature. So you oftentimes find that people will stagger an inheritance over a course of years, 15 years or 10 years.
Okay, gotcha. Yeah, so you definitely want to be protected, like you said, so nothing crazy can happen. And you'd mentioned, you'd mentioned here a healthcare directive and financial power of attorney. Talk about both of those.
Yeah, so very important documents to have. These are for while you're alive. If you do not have these in place and you were to become incapacitated, you couldn't manage your medical decisions or paying your bills. your family or a representative would have to go to court and seek a guardianship or conservatorship in order to have authority to make those decisions for you. So if you set these documents up, it prevents, all that court involvement. It's a very expensive process to go that route. So it's really simple and easy to set up the medical directive and the power of attorney. The medical directive, dictates if I'm incapacitated, I want this person to, make medical decisions on my behalf. I want them to be able to talk to my doctor and make those decisions. You want to name somebody who, of course, will carry out your wishes, who is comfortable in a medical setting. So if somebody is, doesn't really like hospitals, they might not be the best choice. So you might want to talk with who you have in mind first to make sure they're comfortable with that. And I would put maybe a backup person in, but they're great documents to have in place. And there's two pieces a lot of times to them. You've got your, healthcare directive where you're naming your agents and what they can do. And then you have a living will. Oftentimes people want, they don't want to be kept on an artificial means of life support indefinitely. They want that withheld if there's not much else that can be done. Not to sound morbid, but people have pretty strong opinions about that. If you're not comfortable mentioning that, or you want your agent to make the decision at the time, then you can leave that language out. But oftentimes people do want that living will language in their document.
Yeah, it's pretty interesting. Yeah. I mean, what happens if like you're a single man or woman and you have no family? I mean,
that's a great question. I actually serve for a lot of those people. So many of our clients come to us and they say, I don't have anybody local that I'm comfortable with doing that. Some people have named their doctor or physician if they agree to it. But our firm, there's a couple different attorneys at our firm, as I mentioned, and we're happy to help people if they need that kind of assistance. So there's a few people that I serve for who don't have family or friends nearby that they're, trust in that role. So we'll do it if people need us to. So professional, a third party could do it.
And you're listening to the Run It Real Estate Podcast right now, and we have on Julianne Naff, attorney with Anderson, Desmond, and Green. So, this is pretty interesting stuff. So you're telling me if, I've got it in writing and I don't have any family, then you will represent me if I become incapacitated. So I could say, hey, I want her to pull the plug, or I don't want
Right. Whatever your preferences are, we work with you to figure out, what your desires are. You can always supplement these documents. So if there are very specific scenarios that you want us to follow, we'll do it. So we just supplement the document. But yeah, we can do it for people that need somebody.
Now, how does it work in the state of Virginia? Say, so I'm married. Me and my wife have a home. We have a mortgage. Something happens to her, and then all of a sudden I'm sitting here at this house. Does it automatically go to me? Or say it was, different scenarios. Say it was paid for, and she passes away, and I pass away. Does it automatically go to the next of kin, like closest in line? Like, how does that all work?
Okay, well, that's a good question. So as with a married couple, it depends on how the deed is titled. So the deed is recorded at the courthouse, and it shows how you own the property. If you own it jointly as a married couple, most oftentimes it's joint with right of survivorship or tenants by the entirety. So it would transfer completely to the survivor upon the first passing. If you own it, but I have seen it where they've owned it as tenants in common. And oftentimes you'll see that if it's a second marriage or a blended family and they want the proceeds from the sale, to go certain places. So you have to look at how the deed is titled. If it's tenants in common, then it goes through their estate plan. Their 1/2 or whatever undivided interest they own passes through their estate plan. So it depends on how it's owned as to who it would transfer to. But most often, like I said, it's joint with right of survivorship. So it transfers to that survivor. And your next question was if they both are gone, what happens? If you have no estate planning documents in place,
there's no will, nothing.
Mm-hmm. Then it would go in order of, it's a statute, an intestacy statute. If you die without a will or a trust or any estate plan beneficiary designations, you die intestate. So there's a state statute that dictates who it goes to. So it would depend on who your heirs were.
Gotcha. So would it go to the children first or to a brother?
Yes, if you have children, I would drop.
Okay, gotcha. So here's another one. I ran into this one.